So thank you very much. Also welcome from my side in the name of the Geneva Academy on International Humanitarian Law and Human Rights. We are also particularly concerned about this problem of the prisoners in Northern Syria because it is not only a humanitarian problem, but it also raises fundamental legal issues. So first, it is a serious humanitarian problem. It's very difficult to calculate, but there must be something like 2,000 foreign fighters, 3,000 Syrian fighters, and around 11,000 family members at least. The attitude of the international community is a symbol for an old attitude to consider some people so bad that they and even their families don't deserve rights, and this is fundamentally contrary to both international humanitarian law and human rights law. Everyone, as the president of the ICSE said, is protected once detained, and these people are deprived of their liberty. There's also a very serious legal problem, symbolic, for the difficulty of international law to deal with armed non-state actors, in our case, the Syrian Kurds, in whose hands the members of the armed groups are. In the debate, the focus, at least in the international debate, I have been in Syria a long time ago, but not recently. In the international debate, the focus on foreign fighters implies a discrimination which is neither acceptable in international humanitarian law nor in human rights law, neither before a local tribunal in the region, supported by home states, nor before an international tribunal. It is admissible that a difference is made between Syrians and Iraqis who were members of the Islamic State or family members, and foreigners. Foreigners and nationals have exactly the same right and the same regime, with one exception, that home states willing to try them, their nationals may obtain for them the privilege of being tried, everyone in their home state. And obviously, if, say, Sweden or Switzerland wants to try their nationals, they are not obliged to try also Syrian and Iraqi nationals. But this is the only exception, and the humanitarian problems are manifold. Now, from a conceptual point of view, you know that, and here in the Palais des Nations, it's the right place to underline it, international law is still incredibly state-oriented, while in reality, and this is a good example here, armed non-state actors administer territory and detain persons. Now, such an armed non-state actor is certainly bound by international humanitarian law of non-international armed conflicts. Article 3 common of the Geneva Conventions explicitly says that it is addressed to the parties to the conflict. This is much more controversial for international human rights law, but I think that the self-administration in Northern Syria is a good example of why we need also human rights law, because there are no rules in humanitarian law on how to administer a territory, but this is for another discussion. And if you want to administer a territory, you have to legislate, you have to have courts, including on issues which are not linked to the armed conflict, like a husband beating his wives, people stealing goods, and so on, which have under human rights law to be prosecuted such crimes, even when they are not linked to the armed conflict. Now, the people we are speaking about, the detainees, they are either interned or in criminal detention. So the two possibilities, at least in an armed conflict, are to detain some people for imperative security reasons in a kind of administrative detention, or to prosecute them for a crime. If they are interned, there is a controversy whether there is an inherent right in an armed conflict to detain members of the enemy armed group or enemy armed forces. I think this is certainly not a right which is sufficient to overcome the need of a legal basis in domestic law. Anyway, there are procedural guarantees, but obviously it is not easy, even for an armed group willing to provide procedural guarantees, to provide them. Because, for instance, one procedural guarantee is habeas corpus, and there must be a legal basis. Now we come back to the difficulties for an armed group to constitute a tribunal. Here it would only be a tribunal for the habeas corpus. So the possibility to challenge the legality of the detention, to say, I'm not a member of the Islamic State, but I'm a taxi driver who was on the wrong place at the wrong time. And even more so for the family members who can obviously not be detained by the mere reason that they are spouses or children of someone who has committed a crime. Now, if they are tried, and the majority approach, contrary to what academia considers, is to try. Not to say we detain you without trial, but to say you committed crimes and we will try you. They have a right to a regularly established tribunal, and in my view, as Article 3 Common of the Geneva Convention prescribes, that both parties may only try people before a regularly established tribunal. This implies that they must also have the right to establish a tribunal. You cannot ask them to do something and say, but you don't have the right to do it. And so I think an armed group can establish a tribunal regularly. Obviously, judicial guarantees must be respected, and it is not easy for a tribunal established by an armed group to do that. There's also a problem of jurisdiction. I think there's no major doubt that a tribunal established by an armed group administering territory may have jurisdiction over crimes committed on that territory. But most of the crimes committed by members of the so-called Islamic State were not committed on the territory under control of the Kurdish armed groups. And there, under existing international law, it's very difficult to say why this does not violate the prohibition of retroactive penal laws, because at the time when they committed the crime, they were not yet in the hands of the group. Obviously, a solution could be to apply a Syrian criminal law, but for reasons I can well understand, the administration doesn't want to apply the Syrian criminal law. And finally, there is an issue of the applicable law. To say the applicable law must be the law which was applicable at the time when they committed the crimes. So it is objectively and even conceptually difficult for the armed groups to constitute a tribunal for people who committed crimes when they were not yet in the hands of the group. Also, you could say when they committed international crimes, war crimes, many of these obstacles can be overcome. Now, the alternative would be to transfer them either to Syria, but here the no refoulement principle comes, and I mean what we read in NGO reports, in official reports of the Commission of Inquiry about the treatment of such prisoners in Syrian prison. They risk to be tortured, and therefore they cannot be handed over to the Syrian authorities. What Western states now envisage is to hand them over to Iraqi authorities. To the best of my knowledge, there is a serious problem of summary trials. They will not get a fair trial today in Iraq, and the Iraqi justice system is anyway overhand. And the, in my view, hypocritical argument of Western states, which I hear often, to say it is important that these people are judged where the victims are, because then the victims can participate. Believe me, before an Iraqi court, the Syrian victims have as much access than before a Swiss court. There's even a better chance that they can come to Switzerland than to Iraq. The other possibility is an international tribunal. You all know that the International Criminal Court has no jurisdiction because Syria is not a state party to the Rome Statute, and the Security Council refused the Swiss initiative to hand the case over to the International Criminal Court. So the idea is now, in many Western states, they speak about an international tribunal. This could be created by treaty. I mean, Sweden, Switzerland, France, Germany could conclude a treaty and give their jurisdiction, because they have jurisdiction over their nationals, plus jurisdiction, universal jurisdiction over war crimes, could hand that over to an international tribunal they create. But I think on the territory of a non-consenting state, that would be really an incredible precedent, which, Syria doesn't consent. So the question is, where will we have this international tribunal? In Geneva? Okay. But I don't think this is an idea. So finally, that Syrian nationals are tried by local courts, and foreign nationals by local courts, and I think one should help the Kurdish groups to establish the best tribunals possible, or the home countries have to repatriate them and try them themselves. They have jurisdiction. They can try. I would prefer for war crimes. This is symbolically important, because if they are tried for terrorism, you know the old debate, my terrorists are your freedom fighters, while war crimes is an objective criterion, and those who have sympathy for the cause of the so-called Islamic State would nevertheless recognize that for this cause you cannot commit war crimes. And finally, the security fears. This seems to me, but I'm not an expert, very irrational. I feel much more secure if a Swiss national who has fought for the Islamic State is in a Swiss prison than if that person is in a prison in Northern Syria, where at any time there's a possibility that there is a deal with the Syrian regime and these people are released, or these people flee because there's fighting and so on. So I don't understand this very old-fashioned attitude. Some centuries ago you could say if they are in Syria, they are far away and they never come here. But today, it's a few hours of airplane. And so I think we are confronted to serious legal problems, except if we want to do the most obvious thing, to let them be tried by the local authorities or by the home states. Thank you very much.